So as the panel takes their seats, the purpose of this particular panel is, now that you've heard about the ethical and legal considerations that should go into any comprehensive surrogacy piece of legislation, we're now going to talk about the specifics of the Child Parent Security Act and how it fits into that framework. So we're going to start with Denise Seidelman, who is an attorney at Rumbold and Seidelman, and Denise and her partner actually wrote the Child Parent Security Act. So we're going to start with Denise telling a little bit about why she thought there was a need for this type of legislation, what she was seeing in her law practice.
I think you just need to turn you up.
Hello? Hello, hello, hello. Can you hear me?
Yeah.
Oh, okay, thank you. So, oh, too loud. So, the group of attorneys in New York that drafted the Child Parent Security Act, we were all adoption attorneys. And what we were noticing was that people were having children through assisted reproduction, and they were trying to use adoption as a mechanism to secure their parental rights. And that really didn't work. And there were many experiences we all had throughout our practice which demonstrated the need to revise our laws to reflect the reality that this was not an adoption. These were people who were conceiving children that were intended to be their child. They weren't adopting the child from someone who had had a child out of wedlock. And the courts weren't able to make that shift. It was like really fitting a square peg into a round hole. It didn't work. So we reached out to I reached out to my local assembly person, got her excited about the bill, and that was about over 10 years ago. And the rest is history. And so for 10 years, we've actually been trying to get this bill passed. We had the first bill introduced, I think it was 8 years ago. And every year the bill has changed and been revised through a process of people really throughout the country, many on this stage actually, who have participated in giving opinions as to how to make the bill even better.
Could you speak a little bit about the differences between what's in the legislation now that wasn't in the legislation earlier on?
So what happened is New York State studied, the New York Department of Health convened a task force to study the issue, and they, after 3 years of study, they issued a report in support of compensated enforceable surrogacy agreements. So a lot of things that were in that report we incorporated, and a lot of things from professionals across the country. So for example, so what we did, you heard, I think Victoria Ferrara talk about the components of a surrogacy agreement. We really took the best aspects of what would be in the ideal surrogacy agreement, and that was incorporated into our law. So we added in, I'm sort of going not in any perfect order, the right of a surrogate to have life insurance policy, the fact that the terms of her medical insurance coverage must be in the agreement. Any copays or deductibles or any liability she could experience must be set forth in the agreement. She has a right to terminate the agreement until she achieves a pregnancy. It specifically says that she has a right to make all medical decisions, to choose her own healthcare provider, to terminate, reduce, etc. She can't be penalized for making those choices. She has a right, a lot of these specifics were not in the original bill. She has a right to independent counsel. We had always said that, but we said throughout the entire, through negotiation of the contract and throughout her entire pregnancy. The intended parents, it says, need to have a life insurance policy designating a guardian for the child to protect the child. So it has many, many components in that perfect agreement that are actually in the law itself, so that when you go to court and seek enforcement of the agreement, the attorney for both parties, that was added to for both the person carrying the child and the intended parents, have to certify full compliance with all the very detailed requirements of the bill in order to obtain the judgment of parentage.
Denise, could you speak a little bit about some of the constituency groups that you spoke with and how you resolved some of the difference between the different constituency groups when they didn't agree what should be in this bill?
Well, There were very, very many people with very strong opinions that weren't always the same. We had, the very first 2 years of the bill, the people who were most vocal in reviewing the bill were really reproductive rights groups. And Resolve and ASRM, I think, were the most active. And they felt very, very strongly that we could not include in the bill a requirement of a mental health evaluation and a requirement that the carrier be have previously given birth to a child. They are considered best practices in the ASRM guidelines. They also felt very, very strongly that intended parents should not have to have a home study conducted in order for them to be deemed qualified to adopt. So they felt very, very strongly about that, and other groups felt that those components should be required. Ultimately, we resolved it by having confidence that it is in the ASRM guidelines, that any doctor who didn't require, a mental health evaluation would really be deviating from the standard of care. So we felt that it was appropriate to not include that. Those were I think that was the most controversial provisions. And then the other constituency groups, they weren't really conflicting. They just wanted all of those details that I just mentioned a moment ago. They wanted that to be specifically enumerated in the language of the bill itself, rather than left to the parties to negotiate in their contract.
So basically what you're saying is in the absence of a specific protection in the legislation, medical ethics and medical standards to which physicians subscribe to in the American Society for Reproductive Medicine will pick up the things.
That's exactly right. We are relying there, as discussed previously, the physicians involved, the mental health professionals are licensed and scrutinized. They have their standard of care. And so those were some areas where it wasn't actually included in the legislation, but we are relying on the professionals to do what's appropriate in this situation.
So you should all be aware that Denise is part of the coalition that is advocating for this legislation, of course, and she didn't just write the bill. She actually actively works to explain the bill to legislators and tries to get this thing passed really hard.
It's been a very long, long battle.
Long battle.
And everybody knows we're still fighting that battle.
And we are still fighting that battle.
That's why we're here. Okay.
So I'm going to turn next to Richard Vaughn from the International Fertility Law Group. And Rich, tell us a little bit about yourself and your practice before you actually start speaking about some of the things that we're going to talk about.
Sure. Well, I'm a parent through surrogacy and egg donation with my husband. We have twin 11-year-old boys who are just itching to be older. And I also practice exclusively in assisted reproduction and work across the country in this field. For many years, I was the chair of the American Bar Association Assisted Reproduction Committee after succeeding Mr. Steve Snyder, who did it for 7 years before me.
Rich, could you talk about how a prohibition on surrogacy, on compensated surrogacy, actually harms the parties to a surrogacy arrangement?
Well, if I might, I'd like to sort of back up a little bit, echo some of what Denise said, because at the same time that you were starting to write the bill here in New York, there was an academic conference at Aberdeen University in 2010, supposedly to talk about surrogacy, and the conclusion from that conference was that surrogacy is adoption and should be regulated like adoption. So the same thing that you were fighting here was also being discussed on an international platform. And that got the attention of The Hague, it got the attention of the United Nations. And after a number of years of dealing with these counter efforts to sort of explain that surrogacy is not adoption, at the ABA, we got a group together, including the International Academy of Family Lawyers and the Cambridge Family Law Center, to get a conference together to sort of talk about this in a very balanced educational way, to bring in researchers, academics, practitioners, and real people, parents, surrogates, and children that resulted from this process, to come all to one place and speak. We did that in Cambridge in June of this year. And at that conference, we talked about how the world in general looks at surrogacy. And I know we're just focusing on New York, but to give you some perspective, the world does not support surrogacy the way that we do here in the US. But we talked about the different approaches that the world takes. There's the prohibitive approach, there is the tolerant approach, there's the free market approach, and then there's a regulatory approach where we regulate it. And one of the resounding conclusions of the conference was that prohibition does not work. When you just flat out say you can't do it, people are still going to want to be parents, and they're going to go places where it's not safe, where there are no ethical practices in place and the participants are not protected. And as a result of that, they may also be going through these processes without legal support, and then the children may not be recognized, and the parent-child relationship may not be recognized, and ultimately, that's the greatest harm.
Could you put a little bit of meat on the bones of that and explain, give a story or a scenario where there was an absence of regulation or an absence of a comprehensive approach to surrogacy, and what kind of dangers?
I'll give you two examples. So people seeking to engage in surrogacy and do it in a way that was less expensive, they all flocked to Thailand. There was a scandal there, and then it was completely banned, like almost overnight. People were left in the lurch. And there were unsafe practices going on in Thailand as well, so the surrogates were not protected, the surrogates were not given full informed consent or being able to express fully informed consent before proceeding. And basically it was shut down overnight, and not only were those surrogates and parents left in the lurch, we then had to deal with them now going to Croatia and Laos and other places where you would never expect there to be surrogacy. Another example that we discussed in Cambridge was there was a well-known French family, the Menessons, Dominique and Sylvie Menesson, who engaged in surrogacy in California in 2000, and they went back to France and they were prosecuted for having gone through surrogacy. They had twin girls, and after living in France for 16 years, the twins were finally given French citizenship, but they weren't recognized as the children of those parents until a couple of years later, until just this year, I think. So their entire lives, they have not been legally recognized until just recently, fighting the battle in France all along.
Could you speak for a moment about how the CPSA would differ from California law on surrogacy?
Well, the CPSA would include some of the basic protections that Denise outlined in terms of requirements for contracts, but it also has a rather nice feature, a Surrogates Bill of Rights, and it adds as well the ability to not only have surrogacy programs licensed, which doesn't exist anywhere, but it also would allow for the development of regulations of those surrogacy programs.
Those are some really key differences, and we're going to come back to that. But first I want to turn to Sarah Cohn, who's an attorney in Ontario, Canada, to also speak about Canadian law and how Canadian law does it a little bit differently than how we're proposing in New York.
Sure. So Canadian,
Can you just talk a little bit about your practice first?
Sure. So my practice is Fertility Law Canada. I'm in Toronto, Ontario. I practice exclusively in this area. I'm also kind of similar to you, I believe. I'm president of Fertility Matters Canada, which is the Canadian equivalent of Resolve, and a member of the Quad A as well. So Canadian fertility law divides its practice among two levels of law. So we've got the federal law, which is what you're probably already familiar with if you've heard anything about Canadian fertility law, that it is prohibited to compensate surrogate, prohibited to compensate a donor. But we also have the question of who is a parent is answered completely differently province by province. So I happen to live in Ontario, Canada, and our laws are very intention-based. So we have we actually have relatively new legislation that came in almost 3 years ago now. And this legislation really shows that the government has recognized that we've never had a situation where surrogates ever tried to keep a baby in Canada. And I'm not only talking gestational surrogacy, that's the same in traditional surrogacy too. It's just never happened. So they've basically said, we don't need to spend our money and our time making people run through court and having all this oversight over it, when we know that as long as people have taken the proper steps, they've got independent legal advice for the intended parents and for the surrogate, that we know this is being done properly, and we've just never seen any conflicts like this arising, so it's not necessary anymore. So I have to be honest that I don't know very well what the New York statute would look like. I only know quite well what Canada looks like. Something that is quite different is I understand that right now you also have prohibition on compensated surrogacy, if that's correct.
Compensated
Yeah.
traditional surrogacy, yes.
Yeah, could you speak a little bit more about whether Canadian law distinguishes between traditional surrogacy and third-party surrogacy?
Oh, gestational, it actually doesn't distinguish. So to be honest, I think we do probably about 95%, and that's a number that I'm pulling out of a hat. Only this is the area I practice in, so I'm pretty confident that it's very high, as we do almost all gestational surrogacy. But there is actually legally no difference between gestational and traditional in our jurisdictions.
So I'm going to go back to Denise for a second to specifically comment on that and why, and to further illuminate for the room why we no longer allow traditional surrogacy to be compensated.
Well, we've never allowed traditional surrogacy. So it used to be that the prohibition was on any compensation for any surrogacy arrangement. And what the CPSA does is it separates out and says, if the surrogate didn't contribute the egg used in conception, then the agreement can be enforceable and she can be compensated. And what it did is it retained the prohibition on compensating a traditional surrogate, a woman who provided the egg used in conception. And there were criminal penalties associated with violating that prohibition, but they were removed in the most recent version of the bill.
So could you go back and expound a little bit further on the criminal penalties of the current New York?
Well, the current one, they took it out. It used to be that if there was compensation which exceeded what's permissible in an adoption, and in a New York adoption, you can pay reasonable and necessary living expenses 60 days prior to placement and 30 days after. And you need permission from the court to pay anything beyond that. If you violate that, if you're a party, you're an intended parent or a surrogate, then you're subject to a fine of up to $500. If you're a professional who does that, you're subject to a fine of up to $10,000 for the first violation, violation. And if you've previously been found in violation, it's a felony for a second violation. So the prohibitions are extremely draconian. And you know, we do a lot of, just if you don't mind, just for 1 second, we do a lot of compassionate surrogacy cases in New York. That's what we do, that's what we're allowed to do. And in cases where, let's say, a client, an intended parent wants to pay someone who's carrying the child for them for no money, but they want to compensate her because she lost time off from work early in her pregnancy, I'm like, no, you can't do it. That would be illegal, because that's not permissible in an adoption. So in truth, people who consider themselves doing it compassionately, sister, cousin, friend, they're really almost out of pocket for the cost of the pregnancy, because they can't be compensated for all of those expenses they're incurring that wouldn't be allowed at an adoption.
And Denise, can you address one more thing? For a compassionate surrogacy situation, have you seen any problems because New York doesn't recognize gestational surrogacy arrangements at all? Have there been problems even with arrangements that are not compensated between the intended parent and the surrogate?
Sorry.
For example, have you seen questions about who the parent is? And yeah.
Oh, you're asking me? I'm sorry,
Yeah.
I thought you asked Steve. Oh my God, in New York, when the child is born to a compassionate surrogate, the child is essentially the child of the person who gave birth, even though she's not genetically connected. It's really terrible. I mean, there are problems with insurance coverage. I have clients where it's taken months for the child to be covered under their insurance because they don't have proof. They're not legally yet recognized as the parent of the child. There are questions and problems about medical insurance coverage. The birth certificate, when a sister carries a child so she's not genetically related. She's carrying a child for her brother, but it's not her egg. And when the child is born, the birth certificate will reflect a brother and sister as mother and father. And it could be many, many months until that's changed. The stress that these families go through in compassionate surrogacy cases, getting the order that they need, and how long the court takes to process these cases and the Department of Health to issue revised birth certificates, It's a nightmare for families. I mean, we try to work through it, we do it, I encourage people, our colleagues encourage people. It's doable, but it's something they shouldn't have to go through.
Yeah, okay. I'm going to turn to Stephen Snyder now at International Assisted Reproduction Center, And can you tell a little bit about yourself first?
Sure. I'm Steve Snyder. I have been practicing surrogacy law since 1991 for almost 30 years. I took over the agency that I run in 2002, and that agency was established in 1982. It's one of the first surrogacy agencies ever established. And for 7 years, as Mr. Vaughn has referenced, I was the chair of the American Bar Association Assisted Reproductive Technology Committee, trying to develop policies, procedures, guidelines, and proposed legislation to govern third-party reproduction. And when I was chair, we did pass the American Bar Association Model Act to govern assisted reproduction. So I've been involved at a very high level. I was at the Aberdeen conference that Mr. Vaughn referenced. I've sat as the ABA liaison to the International Social Services Group that is developing international policy about cross-border surrogacy. I also sat, along with Ms. Swain, on the subcommittee of the Uniform Law Commission, which evaluated the current amendments to the Uniform Parentage Act. So I've been very intimately related in a lot of legislative efforts, most notably in Minnesota, where since 2002 I have tried to get something passed. It's only been 17 years, and I still haven't gotten anything passed. But you're better than I am, apparently.
It's only 10 years.
Can you move? Will you? So, in any event, that's my background.
So we're hearing from a total neophyte in this area. Could you speak about why you think the CPSA works, whether it's the type of legislation that you would want to get passed in other states, or how it compares?
Well, there have been overarching legislative models proposed. The Uniform Law Commission, the Uniform Parentage Act, the ABA Model Act. A distinction between those two, for example, is the Uniform Parentage Act treats traditional surrogacy differently. It does allow it. It does allow compensation for it. It just requires a 10-day waiting period before the surrogate formally can give up her rights. The American Bar Association Act acts solely on intent, which means whether you're a gestational or a traditional surrogate, if you can document your intent and follow all the protocols of the statute, it doesn't matter whether you do a gestational or a traditional. The New York statute has distinctions between the two. I have to say, being the shepherd of the American Bar Association Act and understanding that intent is the critical distinction in surrogacy, I wouldn't want to distinguish between the two. However, what I've learned in sitting on the Uniform Parentage Act subcommittee is that laws tend to cater to consensus of multiple groups, and you have to find some middle ground. And traditional surrogacy is often the bone that's given up in that fight. But I look at it differently than most people, and I think that's why the American Bar Association Act came out differently. If a woman can be said to be able to be an egg donor and be psychologically evaluated and determined to be psychologically and emotionally capable to give up her egg, and a separate woman can be psychologically and emotionally able to gestate and give up the child, why those two people can't coexist in the same person is curious to me. The problem with that is that historically, there is no legal path to take a child away from a woman who's both the gestational and the genetic mother. So that piece of the New York legislation is subject to some differences in perspective. I don't disagree that it was the right choice to get it through in New York. It was certainly a reasonable area to give up some concessions. I think everything else about the statute is very viable. I think it's been well crafted. There are some wrinkles in the residence requirement I'm kind of curious what Denise has to say about that. I think you have to go with caution when you start talking about agencies and regulating them. So some of the provisions in terms of agency regulation, I think, need to be looked at a bit more carefully. There are some consequences. There's a bifurcation.
Wait, could you stop right there and talk about what you think needs to be looked at more carefully in terms of agency regulations?
Well, now, in the New York Act, agencies have to be licensed, and they are going to be regulated. The question is, that's going to be subject to governmental administrators who may or may not have any expertise in this area. They're going to have a template from adoption agencies. I'm not sure they should be subject to the same regulations. So there's an open palette there that concerns me. When I look at other places in the country, like Washington State, they have essentially said that agencies cannot be operated by attorneys who also draft contracts for parents and have to be nonprofits. And I think both of those are not necessarily good evolutions, because I think the way that agencies run by attorneys under the rules of professional conduct are working well. So I don't know what the dynamic is there, but that's something that I would talk about as the bill goes forward.
Can I just ask for clarification?
Yep.
So it's not that they can't be, is it that they can't be owned by an attorney, or they can't be owned by an attorney who represents one of the parties?
That.
Okay.
Yep. But I think every attorney sitting in the audience that owns an agency represents one of the parties. So that's
That
pretty
you can't do, yeah, in New York.
So that's going to cause a substantial shift, and I'm not sure it's a good one.
Denise, can you speak a little bit to that as to how that arose in New York and why it's in the legislation?
I mean, it was just deemed to be best practice. New York, like, it's very different than adoption, but if you do use that head of adoption, New York has very, very strict laws about conflict of interests, and in New York, if you are an attorney for the adoption agency, you cannot represent either of the parties. So New York takes a very strict approach to conflict of interest. And the perception was that if you are an institutional, if you have a divided loyalty between your loyalty to your matching program, and then you have a lawyer, that you can't give your full loyalty to one of the parties. I know we're professionals. We have to act professionally. We have a code of ethics. But the concept was, why even create that in your head conflict that you sort of have two people that two entities you have to think about simultaneously in one transaction.
And my response to that is simply note that it's rooted in adoption law, which is a remnant of applying adoption rules to surrogacy, and they are different and should not be treated the same, in my opinion.
Right, as we've established in the previous panels and with what's been said at this panel, it doesn't work. There's two different ways that these children are conceived. So your comments are very well taken. I want to turn to Diane Hinson, an attorney at Creative Family Connections, and tell a little bit about yourself first.
Sure, thank you. So I'm the owner and founder of Creative Family Connections. We are a law firm based in the Washington, D.C. area, and but we also do everything that a surrogacy agency would do. But we are a law firm and therefore subject to all the strictures of lawyers, all the ethics rules. So we also do match, and we consider in surrogacy the parents to be our clients, and we are very clear that the parents are our clients, and have the surrogate sign something early on where they indicate that they understand that they are not our legal client. In the DC area, some of my colleagues are here, we were very involved in drafting the legislation that passed in the District of Columbia, where surrogacy contracts were criminal. That took us 4 years to get that through. We also tried in Maryland and actually didn't succeed, but in part it was because when the legislation got too onerous, because of things that were added in that we didn't like, we pulled back. And sometimes those were regulations that were put on that we did not like. I've been doing this now, this is my 19th year, but before I started this, I was in communications. I was actually a regulator and a license. I was the general counsel of the Federal Communications Commission. So I know what it's like to be licensing and to be adopting rules. And so the idea of having this requirement of licensing and adopting rules before surrogacy could start in New York, to me, is off-putting, because I know how long it takes. I know what kind of conflict there can be before you get there. And like most people, I want there to be surrogacy in New York. And I know how long, I know what that process can take. And if you know that you can write the path and have it go your way, that's great. But if it's the wrong people making the wrong kind of regulations, it can actually hamstring it enough that there wouldn't even be agencies. And then you just have self-matching, which I don't really think is what anybody foresees as the desirable path for surrogacy in New York. So that to me is a little bit worrisome.
So Diane, could you speak a little bit about the compensation provisions of the CPSA as compared to compensation provisions in other jurisdictions that you've worked with?
Sure. As some of you know, I've done the 50-state map that looks at surrogacy in all of them. So some state statutes are silent about compensation or specifically permit it. So Nevada has a statute where reasonable compensation may be paid. And like in New York, it must be negotiated in good faith between the parties. Washington allows payment of consideration and reasonable compensation. There was just an ABA brown bag workshop a couple days ago and specifically said you can refer to compensation. Maine compensation is okay. New Hampshire compensation is fine. It actually has a definition of any reasonable, valuable consideration to the gestational carrier. Delaware says that the surrogacy agreement is okay, even if it says that the surrogate will get reasonable compensation. Oklahoma recently passed a statute that says compensation can be paid. The District of Columbia that I mentioned has no definition or prohibition against compensation, so compensation is fine there. California is likewise silent on the issue, so again, it's fine to be compensated in California. Vermont is also silent on it, and so it's okay there. Other state statutes do limit compensation, and so it's not a word that you find in the surrogacy agreements. New Jersey has a very open pro-surrogacy statute. The parents can pay reasonable living expenses, including payments for reasonable food, clothing, medical expenses, shelter, and so the surrogacy agreements are drawn up in that verbiage, but you don't see the word compensation. Florida, which is also a very pro-surrogacy state, also talks about reasonable living, medical, psychological, and psychiatric expenses, but it's pretty easygoing. They can amount to the cost of the base amount. They just can't say compensation. Virginia, where I'm a member, one of the states where I'm a member of the bar, is a squirrely statute that was done, I would say, in an ivory tower. And the surrogate can receive reasonable medical and ancillary expenses. You cannot use the word compensation, and that's been interpreted to mean no lost wages. So in New York, as Denise has talked about, compensation is permitted. It may be paid in accordance with the requirements of the Act, and it's defined. It's defined as payment of any valuable consideration in excess of reasonable medical and ancillary costs. And this will sound very familiar after we heard Michelle Pine earlier. It's the surrogate's compensation is based on medical risks, physical discomfort, inconvenience, and the responsibilities surrogates are undertaking in connection with their participation in the assisted reproduction. So we can guess where that language came in from. And under no circumstances is compensation paid for the relinquishment of the parental interest in the child. Again, it talks about it has to be reasonable and negotiated in good faith between the parties. The payments should not exceed the duration of the pregnancy or the recuperative period up to 8 weeks after the birth. And then we have this Article 44, which is what Steve was referring to, which also it talks about payments, where it says payment means any type of monetary compensation or valuable consideration, and has some prohibitions and of payments. And this is where there's certain requirements that are, some of these are in other states and some of these aren't. Separate escrow accounts are required. This is where you've got the, can't also be owned or operated. I'm not sure quite why that's in the prohibition on payments section, but it is. You can't receive referral fees from attorneys representing a party. You can't receive referral fees from a healthcare provider. The agency actually can't be owned or managed by a healthcare provider. And then, of course, it also has the licensing and requirement. And interestingly, that licensing requirement applies even if only the IVF clinic is based in New York. So in some states, like in California, you can get jurisdiction if that happens. But here, what the Act says is that the agency must be licensed. So if the parents live in New Jersey and the surrogates in the other side of the country, but they happen to use a clinic in New York State, the agency can't match them if they are using a New York-based clinic. That to me is a very far-reaching reach of the law.
I didn't write all parts of it.
I'm not saying you did. Yeah, no, just like I'm sure that you didn't write the part where it's inconsistent as to whether it's pre-birth or post-birth if the parents, only the surrogate lives in the state. So I'm just worried about barriers to entry because the goal is to get surrogacy in New York, and I agree that the adoption model does not apply. You're not matching a child or a baby to parents. You've got two consenting adults.
So Diane, we're running out of time, but I want to ask you briefly if you could speak to the detailed compensation provisions of the CPSA in states that have defined compensation not as clearly. What kind of do you see a lot of disputes post-contract between the intended parents and the surrogate? Is it is that an ongoing problem, or that the CPSA is addressing, or is it overkill on New York's part?
In my practice, I don't see it. I think that it's all resolved based on as long as you have very clear legal agreements. The surrogacy agreement usually contains a schedule that takes care of it. I also answer questions on the surrogacy, on the forum, Surrogate Moms Online, and I don't get questions about that either. I think the main remedy, or the main thing to prevent those disagreements, is having a good surrogacy agreement. And I think that's the most important thing. That's what most of the laws that are being passed now say are important, and having a lawyer on each side and having that set forth and negotiated.
Thank you so much. Yes, of course.
It's not that they can't be owned by a healthcare provider. They can't be owned by a healthcare provider providing services to one of the parties to the surrogacy.
Yes. I'm sorry.
Yeah. So they can. Yeah.
The very clear conflicts that we have, interests that we have in New York. So I want to thank this panel very much.